Our next sort of segment is on legislative activities, and we are very lucky to have Paul Hill, who is the bar's general counsel, and Jim Daughton, who is the bar's lobbyist, here to share with us on this rather fascinating topic.
Hello, everybody. I'm Paul Hill. I am your almost never specific and usually general counsel. But I'm your kind of go-to guy for section advocacy in the legislative arena or in an amicus context. So go to me if you need to. I'm otherwise sort of the resident bar junkie on staff. We are all members of a unified, integrated, or mandatory bar. It's an interesting creature in the political science landscape, but in fact, 32 states in our country and the District of Columbia are in this kind of a bar configuration. But our federal system shows it's best by the fact that virtually no other state unified bar is similar to Florida's. I think if we've got a clone anywhere, it's probably the Oregon bar that resembles us the most. But in fact, there are unified bars that have their budgets determined by the state legislature or jointly with their own state Supreme Court. We are fairly pure, I would submit, however, but in most instances, unified bars are all-in-one organizations. As you might appreciate, there is no Florida Bar Association to be our mirror. You may have a Board of Medicine and then a Florida Medical Association in the state of Florida, but indeed we attempt to be an all-in-one organization, but that's where some of the troubles do crop up without a doubt. No state has ever flipped from mandatory status to unified status, even though the Wisconsin bar did play around with it in the late 80s. So this is the predominant bar configuration that you will see all over the country. But to bring us to life, in Article 5, Section 15 of the Florida Constitution, you will see, again, that our Supreme Court has exclusive jurisdiction to regulate us. So this is the basis for the two agencies or arms of the Florida Supreme Court. From this one constitutional provision, you have, by court rule, the Florida Bar for the discipline portion of this arrangement, and for the admission side, you have the Board of Bar Examiners. So that's where we are today. Stemming from that constitutional mandate, of course, we have our own organic document, the Rules Regulating the Florida Bar, and that document affirmatively states that we will indeed have such a authorized corporate activity to be engaged in a legislative program. Elsewhere in those same rules, we have some other corporate activities that are specified for the organization, but that is our basis for existence in our own organic document. That forms the basis for a governmental affairs office staffed by me, and I've got my assistant hiding in the back of the room, Miss Joni Wussler, who you need to meet and know in your future bar work. But our office advises, coordinates, and informs, and we actively publish the bar's legislative platform on our website. We, most importantly, pre-screen every bill when it is released, and if you are unaware of it, and if you go on our folder, on our website, there is a folder for every one of your organizations, every bill that we think may be of any interest to practitioners in your discipline or members of your section. We have put it in a folder that activates a tracking system. You can follow the parliamentary progress of every bill that we have tagged for you. You can get copies of the bill, amendments, and staff analyses. And our website also gives you guidance on how you can indeed track a bill through our own very good state legislative website. I commend that to you. Our website should be very, very helpful. In Section 8 of your materials is a series of pieces that I do commend to you. You will get more narratives on our bar's legislative program, and you'll also get some of the case law history that I want to pass on to you. Again, you can't see these sites real well, but nonetheless, this is where we do provide a master list of all the bar's legislative positions, your legislative platform as well. And then you've got the bills of interest and some of these other sites as well. Some of you who are active in your own section's legislative programs know at this very moment we are in our sunset mode. We have just seen another legislative biennium pass. Essentially, the biennium ends this summer. We'll have November elections and a whole new legislature. So if you're unaware of it, all of your sections have been informed of this process. It's the opportunity to take down our platform, if you will. All of the sections have reviewed their positions of record at the moment. If you've got some moot issues, if you won some victories, or if you've changed your sentiments, this was the opportunity to refresh your platform. We will take those requests from you to the Board of Governors next week. They will essentially roll over your positions, and you'll be good to go for the 2014-16 biennium with the positions that you have always had. They should be reaffirmed without any difficulty whatsoever. But you'll find all of that on the website shortly, and I do predict good news for next week. Case law, here we go. This is back to the good old First Amendment stuff. In your materials is really a running narrative of the history of the case law related to unified bar advocacy. It's been a real hot issue, quite First Amendment driven. In the 90s, we had a series of cases coming out of California, Wisconsin, Arizona, Puerto Rico. We had state bars, particularly California, all over the chart in their advocacy. They were taking positions on armor-piercing rounds, nuclear proliferation, things that were not at all related to the basic purpose for why we have a unified bar. And indeed, the case law essentially affirmed, again, the justification for a unified bar. This issue had been litigated in the state of Wisconsin in the celebrated Lathrop versus Donahue case. And the constitutionality of the unified bar has been pretty much established, but its only real justification is to assist in lawyer regulation and essentially to improve the delivery of legal services to the people of this state. The litigation in Florida sort of culminated in a case called Schwartz versus the Florida Bar, and then we even had a challenge to some advocacy the bar was involved in the Frankel case. Coming from those court opinions was a good set of standards for what the big bar could do with the money that we take from you in the name of regulation and professionalism. And these were essentially the bright line subject issues that were considered acceptable for bar advocacy. Questions concerning the regulation and discipline of attorneys, functioning of the courts, judicial efficiency and efficacy, increasing the availability of legal services to society, regulation of attorneys' client trust accounts, which you certainly hope the legislature is not going to ever be involved with anyway, and then the education, ethics, competence, integrity, and regulation as a body of the legal profession. These things, according to established U.S. Supreme Court case law in the Keller versus California case, were clearly considered acceptable bases for underwriting bar advocacy, even by those who opposed it or wanted to dissent from it. Then, however, in our Schwartz case, we learned that there may be sort of a secondary zone in which other advocacy might be allowed. And then that's sort of a three-part test that requires really all three. The issue's got to be recognized as being of great public interest, that lawyers are especially suited by their training and experience to speak on the issue. That actually trapped us in the Frankel case. We were kind of out of our orbit in that litigation. We were involved in some women's health issues and really had maybe crossed over the line into some medico-legal things. And indeed, in the Frankel case, we learned that the big bar had gone just a little too far in its advocacy in the early 90s. But then lastly, the subject matter has to affect the rights of those who are likely to come in contact with the judicial system. Sometimes these three criteria have to be utilized in sitting in judgment of a big bar position, but that's indeed where we are. Lastly, however, was an admonition that we got from the court in Frankel, and it has really been one of the other criteria that comes into play in many, many cases, and that is whether we are involved in an activity that may indeed carry the potential of deep philosophical and emotional division among a substantial element of our membership. Interesting stuff. That's what your board is involved with regularly when it sits in judgment of matters that they want to advocate. Again, the holding of the Keller case law. Important stuff. This is still really what guides the big bar in its advocacy. This is again a justification for why the unified bar is okay. Our state interest in regulating the legal profession and improving the delivery of legal services. Therefore, you can indeed pick the pocket of even a dissenting member if indeed you have to. Thank God for you folks. The case law is all about whose money are you using and whose name are you advocating. When the big bar is on the Hill, that's the important issue. Luckily, because the big bar's zone of approved advocacy is so narrow, but luckily quite noble, it leaves a lot of the sexy bread and butter stuff kind of out there for somebody else to deal with. And in reaction to the 1990 era case law, which got us into a labor law analogy. The agency shop fee cases, of course, smoked out the concept of people who didn't want to underwrite activities that they dissented from, but they were forced to belong to big labor organizations. There had to be dissent mechanism employed and the like. But that case law never had to cope with the notion of a subunit or a section like we have in a bar world, which indeed has its own independent treasury and separate from the mandatory membership features of the unified bar, has its own voluntary membership. Like the voluntary state bar associations elsewhere in the country, you folks are sort of mini bars, as we like to say. But our case law, our state Supreme Court, and our governing board has set up a system that essentially depends on sections to carry the ball for the real pocketbook issues for the profession. So far, that system has survived the test of time. It has been objection-free, I might add. It's understood by the bar membership, most importantly understood by legislative leadership. But with your money and with a Supreme Court rule that admonishes sections to clearly distinguish themselves from the unified bar, you folks are able to really fill the void and deal with the important matters in your areas of practice. Most of you have active legislative programs. Some of you have your own hired gun lobbyists who coordinate with the bar's lobby team. You have prestige and credibility on the Hill. I want you to be successful in what you do. My office is ready to welcome you and get your requests before the Board of Governors in as prompt a manner as possible. What you need to know is even if you have no partisan position on an issue, there are ways that you can still be influential on the Hill. The notion of mere technical assistance to lawmakers is a absolutely wonderful area to go into. Some of the smaller bar groups who come to me say, I don't have a lobbyist, we don't have a treasury, what do? You have prestige and you have credibility and you are authoritative. Come to me, I can help you nevertheless package your sentiments, get them before lawmakers, and I think make you influential in the process. We have a system by which you have within your materials the governing legislative policies of the bar. They're fairly intuitive. We're a family, if you will. There's a mother may I component to it. You fill out an abominable form on our website, but it essentially informs the decision maker of what it is you want to do. You describe the issue. You may have a draft bill. You may be reacting to a bill already in play. You give us the history of your advocacy, if there is any. And then most importantly, you help, with my help, you tell the Board of Governors who the other members are in the bar family, who may care what you're doing. If you will reach out and inform your brothers and sisters in the bar of what you're doing, you can move through the process and you will be granted the freedom to advocate in almost every instance. The only criteria that are employed for sections are you within your subject matter jurisdiction? Are you off on an issue that collides with an existing big bar position? And then lastly, are you so far out there in your advocacy that it may be troublesome to other elements of the bar, back on the divisive issue you saw earlier. There are still residual First Amendment questions about unified bar advocacy. I don't think we're ever going to know the entire answer to all of these questions, but most of the issues have been settled. As long as sections in their advocacy don't go totally off the chart, they can operate under the Unified Bar umbrella, enjoy the prestige of this organization, and I would submit be effective on the Hill. That's what we certainly hope. The standing board policies are in your materials. Again, you'll see the three criteria that are employed: subject matter jurisdiction, no conflict with a big bar position. And let me add that our policies read that if you want to go somewhere even beyond where the big bar may think it can go, you may go there. That was essentially a consideration several years ago when the family law section got into litigation with an amicus brief in support of same-sex adoptions. That was probably even beyond the authority of the big bar, but nonetheless, the section was granted the authorization to proceed. So I say that the opportunity for section advocacy is virtually limitless as long as you kind of keep it between the ditches. Who's in charge? Certainly not me. We have a 9-member legislation committee. We are honored to have our chair-elect among us, Bill Schiavino. Stand up. You got anything to tell this crowd?
No, good morning. On behalf of our committee, first thing I'd like to say is working with Paul is a privilege. This is one of the hardest working committees on our Board of Governors. It really is. We work hand in glove with the President. At times, our committee is very active. There are times when we are not as active. Hopefully this year will be somewhat in the middle to the light side. And Jim and his team, we've worked with Jim, his partner Steve, for many years. They're absolutely terrific. Lastly, we want to work with you. Mike Tanner couldn't make it. Mike is our chair this year, terrific guy. Mike's from Jacksonville. I'm from Tampa. To the extent that we can help you in any way, we want to, the team concept is important to us. And so any issues come up that we can help with, feel free to call either one of us. Thank you.
Thank you, Bill. This is an exciting and dynamic area of the law. The labor law analogy that the integrated and unified bar world is subject to is constantly changing. We had a U.S. Supreme Court opinion this term in Harris versus Quinn, another kind of agency shop situation, but it really kind of rose and fall over whether those were state or local employees. But at the moment, we think a lot of the First Amendment implications merely apply to advocacy-type activities. We have some other state bars that are kind of withdrawing. They are trying to run bars on a straight Germanity basis, if that's the way to term it, and still want to know whether the activity that's forced on the dues-paying member is still really germane to the constitutional basis for putting folks together again. So again, it's regulation of the profession and delivery of legal services. In your amicus activities and your legislative advocacy, we certainly have to be mindful of the First Amendment issues. But as Greg Coleman mentioned, we got to have a national bar someday, and we may have to re-scramble the egg, who knows. But at the moment, given our current bar configuration, you folks are where it's at. I'm here to hope you get the legislative fulfillment you want. Our profession needs you, and what sections do is important. And then never, ever forget that every individual lawyer has the freedom to lobby anytime they want. There's no restriction on that from this organization, and we'll take the help of everyone we can get. I'm going to turn you over to Jim Daughton, because Jim can certainly tell you about the exciting things that have happened so far on the Hill, and he can give you a real good glimpse of what's coming in the state legislature to come. Jim Daughton.
Hi, good morning, everybody. Again, Jim Daughton with the firm of Metz Husband Daughton, and I'm part of the team that represents the Florida Bar. I usually walk around during the legislative session with Keller, Schwartz, and Frankel rolling around in my head to make sure that the bar is taking positions that it's supposed to take, and that I'm advocating in a way that stays within the confines of that. Oftentimes when you meet with a legislator, and I know a number of people in the room have done this before, but you'll get the 5 or 10 minute meeting, and oftentimes I'll get called in and they'll want to know if the big bar can take a position on something. And so I start with this whole Keller, Frankel, Schwartz, and go through the tests that Paul laid out, and then my 10-minute meeting is over and I try to slink out and get out of doing any real work that they're asking me to do. I do want to talk about the legislature. Sort of once the sections have gone through this procedure, what happens next is that you confront decision makers. The current legislature has 120 House members and 40 senators. You'll see the partisan makeup there. We're just about 2/3, 1/3 are Republican to Democrat. Of course, that can change. I think that the Democrats were in charge in through the mid-90s, and but that's the current layout now. Also, we do have a number of lawyers in the legislature. I'm not sure Mr. Harkness might question sometimes whether that's a good thing or a bad thing. I'd argue that it's a pretty good thing to have members of your profession in there. I suspect that doctors and others would love to have that many of their profession representing them in the legislature. Just because they're lawyers, however, does not necessarily mean they wake up every day and sort of worry about the Florida bar's issues. Obviously, I think their training is helpful. It also doesn't mean that they're always going to agree 100% with the Florida bar's position. But there are a number of them, and we try to work and target them, frankly, on big bar issues. They usually have a step ahead. Those were the senators I posted. These are some of the House members that you may recognize from your part of the state. The two leaders that are coming in after the November elections, the incoming Senate President, incoming Speaker, Andy Gardner is a Stetson grad, Mr. Coleman. He currently lives in Orlando. He's been in the process a long time as legislators go. He was first elected in 2000 and served 8 years in the House, and then moved into a Senate seat. Andy works for Orlando Health, which is a hospital system in Central Florida. I would say that he's not going to wake up every day and worry about legal issues as they impact the Florida bar or its sections. He's been keenly involved in economic development issues and some healthcare issues. It's sort of been his passion. I think Senator Gardner would tell you that he plans on hitting a lot of singles and doubles and not swinging for the fences on a lot of things. He's a pretty he's a plotter as he moves through things, and has been highly effective. So we'll have the opportunity to be working with him more closely as he moves into this new role. On the House side, Steve Crisafulli is the incoming House Speaker. He's from the Space Coast. His family's in agribusiness over in Brevard County. He, again, is not going to wake up every day and worry about bar positions. His passion has been water issues and agriculture-related issues. I brought a healthcare client to have dinner with him in his district, and we were out at the port in Port Canaveral, and I'm trying to talk about various healthcare issues, and he's talking about how the ports are the economic drivers for the state, and talked about water issues and agriculture issues, and my healthcare client was wondering what the heck he was doing there. So I suspect that you're going to see a lot of activity, at least on the House side, on those type of issues moving forward. I want to talk about what's currently happening in Tallahassee now. A lot of people have a misconception that Florida, like other southern states, is a 60-day legislative session, and you don't do much the remaining 10 months of the year. Unfortunately, that's not the case. Right now, for example, the legislative budget, the state agencies are developing their budgets, including the courts. The court is developing its own budget for the 2015-2016 fiscal year. I think those of you involved in government would know that the worst job is to be on the budget staff in the governor's office. They never seem to stop or take a break. They just finished dealing with the recently passed budget, and now they're going into startup, as they call it, for next year. The legislators, of course, are not in town. They're back in their districts and worrying about things like re-election, and we'll talk about that in just a few minutes. We do have some elections, if anybody's been paying attention, November this year. All 4 cabinet offices, including the governor's races, are up for election in November. Also, 20 of the 40 state senators face re-election. 8 of them, however, are running unopposed after the qualifying period just ended last month. And in the House of Representatives, we had 35 of the 120 members who are unopposed and were automatically reelected. Term limits is something that, as Matt was making his comments a little earlier today, made me think about term limits. There's a tremendous amount of change now in the legislature due to the 8-year term limits. Sometimes it feels like you've never really solved a problem, or that you keep having the same conversations over and over again, and it's because the legislators are different. So when Matt was talking about the need to have a communication and pay attention and have sort of a linkage between what used to happen, and there are no new issues. We see that in the legislature all the time. We do have there's some startling statistics, I think, about half of the legislature has served less than 4 years. So we have this term limits dynamic. We also have committee chairs and committee membership change every 2 years. So if you're trying to develop a champion for your specific section, and you've picked somebody in the healthcare arena, for example, that person may not be on the healthcare committee after 2 years. So it's ever changing, and that's why it's very important to work year-round on developing those relationships and making sure that your legislators know what issues are important to you. The legislative session itself, just in terms of timing and process, after the November election, we'll have the legislature back in November, in mid-November, to get sworn in, and it's called their organizational session. Typically, there's not much that goes on there, and then committee meetings will start for real, I guess, in December. That's typically when we'll find out who the committee members and committee chairs are going to be of the newly elected legislature, and then the committee meeting process will continue through December. Couple weeks in January, typically 3 weeks in February, and then the legislative session begins. For those of you who've worked in the legislative arena, you know that typically bills get passed in the summer, so now's the time that you'd be having conversations about what you're trying to accomplish in the 2015 legislative session. You also want to try and get your bills filed in January or February, and you're going to hope, even before then, because you're going to hope that that bill will get heard in a committee in that January-February time frame. As you move into the legislative session, you need to consider it like a big funnel, right? And there's just the days go by and the issues narrow, and if you're working on filing a bill the first week of the legislative session and it gets referred to 2 or 3 committees, it's very, very difficult to move a bill that quickly through the process. So for those of you who have outside counsel who do the legislative stuff, they all know this. Paul can certainly be a resource, and we can be a resource to you on some of these timing aspects, but you have to be early to just, the process is not designed to pass every piece of legislation. In fact, there are about 1,800 bills that were filed this year, and less than 10% of those made it through the finish line. So start thinking early. The legislative session does start, by the way, on March 3rd this year, and the only bill that they have to pass is the state budget, which is around $77 billion now. We have one of the top 20 economies in the world, I read somewhere, so we're spending a lot of money here in Tallahassee. Some of the issues, no surprise that you'll see, I suspect, Paul, after next week, you'll see some of the bar's positions get renewed. But we work very closely with OSCA and the Supreme Court to ensure that there's a stable and fair funding for our separate branch of government and the judiciary. Unlicensed practice of law issues were very prevalent this past legislative session, and again, that's where we have to sometimes assert the independence of the judicial branch of government and how that works in a regulatory environment. We also work on civil legal assistance funding for the poor, which the legislature has appropriated a couple of $1 million a year for the last 4 or 5 years. The last 4 years it's been vetoed. So when Greg talked about the need to really address how we are handling representation of the poor, we're going to be starting at ground zero, at least from funding from the legislature. And then obviously for the government lawyers in the room, every year we work to ensure that your employing agency has the ability to pay your bar dues. And we've been, I think except for 1 year, Jack, in the last 10 or so, we've been pretty successful in ensuring the agencies have the ability to do that for government lawyers. Paul alluded to this. I cannot tell you, and certainly Booter knows this too, how often the Florida Bar that name, the Florida Bar, is bantied about during the legislative session, and it's frankly something we should be proud of. As lawyers, we're looked upon as issue experts in a number of instances during the legislative session, and my ears always perk up. There'll be a business law question, and they'll say, "Well, what does the Florida Bar think of this?" or a family law issue issue. What does the Florida Bar think of this? Then I go through that whole Keller-Schwartz-Frankel analysis and try to put them in touch with the right person from a section. Usually they're talking about a section. As Paul said, that's where the bread and butter issues meet, and a lot of our time is spent connecting legislators to the right section, whether that's through a lobbyist if the section has one, or putting the legislator directly in touch with the issue experts. So I want to emphasize Paul's point earlier. It really does make a difference. They are looking for third-party validators. They're looking for some impartial information. They're looking for some real-world experiences, and we really do a good job, I think, of providing that to them. Many of you have been involved in talking with legislative staff or legislators directly about how a particular policy issue impacts a policy area or the practice of law. Oftentimes you'll see members of the bar providing committee testimony, helping with drafting, and really providing their expertise. I also want to mention a little bit of a coalition we've put together. We realized about 5 years ago that many people are interested in court funding issues and making sure the judiciary is functioning properly and is adequately staffed, including the business community. And the argument we've made, of course, is that if you don't have a properly functioning judiciary that's staffed properly and well-funded, that business cases can slow down and it could take a long time to get through the process. So we put together a group of the business organizations in Tallahassee who participate with the section lobbyists and with our bar team to talk about issues that matter to all of us. Mostly they're around funding issues and trying to get their assistance and talking to legislators about making sure the judiciary is funded appropriately. And that's something, hopefully, I think, as Greg mentioned in his comments, it's that platform that hopefully will be built upon in his work with Chief Justice Labarga and Attorney General Bondi. Just some dates to remember. The fiscal year begins July 1st, so if you see where the money starts to flow, it goes from July 1st through June 30th. Elections are coming up, as August 26th is a primary election, and the general election's November 4th. Agencies, as I mentioned, are putting together their legislative budget requests. The governor will take all of those and has to present that product to the legislature 30 days before the start of the legislative session. And honestly, it typically does not matter whether there's been a gubernatorial election in between. For those of you on staff, typically the new governor, if it's a new governor, will build on the agency budget requests from the prior administration, especially in that first year. They're sort of too far down the line in the budget process to make significant changes. As I mentioned, organizational session will be November 18th of this year, and then the session begins on March 3rd. Paul went through most of this, but what we do is try to send a session report to the Big Bar and the Board of Governors every week during the legislative session. The website's kept up to date, the tracking system. Presidential messages are always helpful when there's a key issue of importance that's going on during the legislative session. And then you'll see a lot of coverage about the legislature in the Florida Bar News, and you can certainly contact Paul or our team at any time. So I hope that helped. I'm glad to take any questions if you have them. Yes? Federal lobbying?
Let her repeat the question.
Oh, that's right. Just repeat it again.
Does the bar do any federal lobbying?
The extent of the bar's federal platform is usually influenced by what the ABA may be advocating. Not everything that the ABA advocates is acceptable for our unified bar to advocate, but certainly federal issues that the ABA is interested in typically get a look and usually get a Me Too position from the Big Bar. Sections are welcome to have a federal platform if they're so inclined. I'm unaware of any at the moment, but that territory is open. The extent of our involvement is typically just a letter from bar leadership to members of the Florida delegation. And then again, if there's an ABA campaign going, we follow their lead and try to do as they suggest. Is that helpful?
Yes, sir.
Mm-hmm. I do encourage all of the sections to have a legislative chair. Most of you do. I can't stress how much a call to my office will probably save you heartburn as a section leader. More times than not, we have problems if you go off too quickly and kind of hadn't checked in, but I try to be helpful. And again, if you're thinking advocacy, either in the amicus context or the legislative arena, hail me up and I'll try to demystify and make it simple. That's it? Okay, I know y'all are dying to hear Marcy, so we don't want to take up any more time.